process required under Nevada revised statutes. It's the first step in actually implementing regulations, and the first step is to take input from the public on those that either the staff has proposed or the law has dictated. And then we have there'll be 4 separate areas that we'll discuss. The 3 of them have documents that hopefully you've got copies of up front. And the documents that will be in those 3 have small business impact statements, the list of the regulations that are looking to be proposed or changed, and then for those that are already been worked on by the staff or the Legislative Council Bureau, the laws as proposed that are already completed. The 4th item, well, let me go through those 3 so you'll know which ones we're going to put together. What I would suggest you do is look through your documents. The first document will be a small impact business statement, small business impact statement relating to hair braiding and hair braiding establishments. And that document goes with the recommended hair braiding regulations document that should be attached to it. Those 2 documents will be discussed as one unit when we get to it. The second group of documents that you should look for is, again, a small business impact statement. On the second page, you will see a list of NACs that are proposed to change. And the first one on that second page should read NAC 644.320 restroom. That document and the small impact statement goes with the second document, which has proposed regulations LCB R145-10. Does everybody find that second document? And they go together. Those 2 documents go together. The third set of documents will be a small business impact statement. On page 2, you will see NAC 644.151. And those 2 documents go together. And then the final document, the 4th topic, will be surety bond levels and an alternative method for payment for students to minimize exposure for liability. And in that, we have no impact statement yet, because we've not received enough input on that dialogue to date. And then we have 3 proposals that have been submitted to the office from interested parties to deal with surety bond and alternative method of collection. And those 3 documents are the James Albert School of Cosmetology submitted one several weeks ago. The International Academy of Style has 2 documents that really are the 5 schools in northern Nevada got together, and this is what they've submitted as 2 alternatives for dealing with the SB 193 proposals for school bond requirements. There are 2 different models that they presented forward. Their priority one is the one that has A and B, and the second choice in their mind will be the one that has A, B, and C in the first part of each document. Okay, so those are the documents that we've received to date. We've not received any other input from the schools in the southern part of the state. The board has conducted a similar workshop on the 12th of September in northern Nevada, and this is the duplicate meeting workshop today on the 26th of September to receive input from the field. No decisions have been made yet, and the staff will then be directed by the board after the completion of the second workshop as to some things they'd like to consider for the public hearing that will be conducted between 60 and 90 days from this date, because the LCB, the Legislative Council Bureau, requires a minimum of 30 days of submission after submission of the proposed regulations. and recommended that we not schedule any meetings for at least 60 days after the final workshop meeting. Then they will allow us after that to host a public hearing on the regulations, which the board will then make decisions as to which regulations they want and the configuration of the regulations. Staff will then prepare the regulations in final form, and we will post those on our bulletin on our website. And there are copies here if anybody's interested in seeing what that public hearing actually produces. And then they'll be submitted to the Legislative Council Bureau for review. And what they really do is rewrite them in the proper language, place them in the right proper places, and make sure they're consistent with all of the laws of the state and are compliant with all requirements of the rule-making process. So that's the process here. Today, the board will be taking input from the field. They're not going to be talking about and arguing about which is the best way to go, but they'll ask a lot of questions. They may ask you to clarify if you have an idea or direction you'd like to go. They'll ask what you clarify so they truly understand it. And if you have anything to propose today, we would like copies of it today so we can put it on the record. And if you come up with something a week from now, you need to send it to us as soon as you get it completed so it can be included in the record. We are required to maintain a record of what was proposed and the dialogue involved. This meeting is recorded but not for public consumption. It is only recorded so we won't forget anything or miss something in the dialogue. It is not being transcribed otherwise. And the minutes that will come out of it are only going to be eventually it will take a couple of weeks, so it will be the regulations that have been submitted and the direction of the board as to which direction we're going to go on the regulations. But there'll be a record in the office if anybody wants to see what proposals were actually offered forward. Okay? Mr. Lee.
Mr. Jim, no, I just wanted to remind every one of you that if you do want to address the group, if you just would please mention your name before you begin speaking, so everybody knows who everybody is. That would be helpful. Thank you.
Has everyone signed in on the sign-in sheets? That's a way we can show the legislature that we in fact had a public meeting and how many people attended. The Northern meeting had 4 school representatives, actually 5 people, but 4 schools were represented, and then about 13 or 14 students came voluntarily. They didn't get credit or anything, but they came voluntarily to listen to the dialogue and be part of the dialogue, the discussion. With that, we can go ahead and get into each discussion. The first discussion I want to hold, though, is the one that's the most time-consuming and probably the one of the most concern, and that is the surety bond issue. And there's no 2 document papers on that because we've not had enough input yet. So there's no way we can indicate without getting public input from the schools and interested parties if there is a fiscal impact, a cost impact of any of the regulations that we might come up with. In that dialogue, there's just 2 regulations we're looking at. One is the level of the surety bond. And what occurred in the SB 193 dialogue at the legislature, the board had come to grips with the fact that surety bonds had not really done what they were designed to do by design, and had opted to recommend to the legislature a full repeal of the surety bond for all schools, and that determined that it be a contractual agreement between the school and each individual student, because that's what it is now. The legislature repealed it in the Senate, where it was introduced, but did not repeal it in the Assembly. There was a significant amount of dialogue and an amendment to the legislation that was forwarded by Dr. Hardy, who's a senator in the in the state legislature who agreed to sponsor the bill and what the board wanted. And the Assembly instead asked the board to modify its bill to include two alternatives. The first alternative is a reduced or a new surety bond requirement as an alternative for each school to select, or the school on their own volition could select a second alternative, and that is a new collection system that would minimize the exposure of the students to liability should a school suddenly close, either from bankruptcy, going into protection, or just the people wanted to close it and close their doors with students still left at bay. So the legislature has asked us, with the board, to take the responsibility of designing a new surety bond level and the alternative payment plan that must be crafted something similar to the state or the United States Department of Education's Title 34 payment plan system that the schools currently use with federally funded students. Doesn't mean it has to be exactly the same, but it has to be something designed similar to that, using that standard. And that's where we lie today. At this point, we are in a position where we have to come up with what's a reasonable amount of surety bond, who should qualify for it, and if the school itself wishes not to use a surety bond or cannot afford one or doesn't have a sufficient properties put in as collateral or liquid cash as collateral, they can take on their own volition to go a different direction and use the payment plan, which allows them to survive without the surety bond but minimize the exposure of the students. So that's where we are today. So do I have, at this point, I can tell you what the three opportunities have been. You can see them in the paperwork that you've been given, the three options. I have not heard from anyone else except these 5 schools in the north and the one person who submitted on behalf of James Albert Schools that you see on that proposal. So with that, we'll take testimony. I'm going to put a chair up at the testimony stand, so you don't have to stand up if you want to testify. Is anybody interested in testifying before the board to add a new idea, a new proposal, support for proposals that you've seen? Please come to the testimony table.
Good morning.
Introduce yourself, your name, and who you represent.
I'm Gwen Bramo, and I represent Expertise Cosmetology. We have had some dialogue with a couple of the schools, but I think we wanted to my main concern today is I wanted to see what the board had already proposed or what they're proposing to do. So what I'm asking is we could get together and submit something by the end of the week. Our
Yes.
recommendation.
Yes. The board hasn't decided on anything yet. We're just here to listen. And so as soon as you can draft something, just please forward that to Mr. Juneau.
Well, we have something pretty much draft, but the last meeting I wasn't quite sure, and I kind of felt that we should wait till today to hear what was already proposed on the table, and then we could go back as school owners and discuss what we feel that we would like to see post. I mean, including taking in consideration what the other schools have already submitted. Now that we have something to kind of guide our recommendations by.
Gwen, we have not come to grips with any of the final decisions at all to put it on the table. That'll come at the public hearing, but it would be good for you to do input as soon as possible. And then, like I said, we're sharing all the information we received to date. And then as soon as we can do that, we'll begin to craft a solution that the board will take a quick look at, say if you're going the right direction. Then we'll have the public meeting, public hearing, where everything will be on the table to argue about and adopt. Now, when they adopt it in the public hearing, it only means that they direct me to proceed in that direction. After that meeting will be after the public hearing will be an adoption meeting, which means the final wording that they want to see to go to the legislature will be done. That's the process. So we got about 60 days to get our act together. So as soon as you get your ideas on paper, we'll include it in the record.
Okay. And you're saying that you will have something by the end of the
Well,
week?
when we left the last meeting, we kind of got together and, went back and forth with dialogue over email, but we haven't just kind of put it in form where maybe recommendation 1, 2, or 3.
Where are you sort of kind of at? Just as a free form? I mean, just to open it up and
Okay,
get
well,
the ball
it's kind
rolling.
of pretty much what they've already kind of proposed to, we kind of said that if you were accredited, one of them, I'm just going to just throw out there, okay? Like if you were already an accredited institution and you had Title IV funding, then maybe we can come up with some kind of system. I didn't know about, one school kind of wanted the system where they had, like in California, where they put so much money in, and then we talked about that. And then we also talked about if you wanted to continue your bond, then you can have maybe a lower bond amount. And I really don't have a problem, looking at maybe some type of system, like if you accepting your payments. But what I did, like the Department of Education standard, how we, the money's dispersed in increments of how many hours the student has already, right. Okay, getting tongue twisted here, kind of like talking to everybody, looking in one direction. Okay, so what we kind of have some of the same proposals, but we did have them, and I just kind of wanted to go back and sit with the other school owners just to see, so we can all be on the same accord, like they were on the accord up north. But what I didn't really want to see, and to be totally honest, is the board to pretty much regulate how the schools are receiving their monies. Like I don't know how this financial issue go, because I know how people can fudge financials. Financials, everybody has a CPA. I'm sure in this business. And just submitting documentation stating that this is how much money that your school is taking in from the students. And I just feel that, personally, me, is not something I would probably want to do.
So like an auditing from the state board of your business.
I think the state board has a really big job already to do. That's just on the outside looking in. Then to be auditing the school's financials when you already have CPAs and bookkeepers that's already doing that. So that was kind of something that I'm not really for if it was still on the table. But it kind of sounds like with one of these options, you would have to be submitting something to the state board to show.
But other these options are not from, the proposals are not from us, because we haven't made any.
Right.
Right, so, I appreciate what you're saying, but as a board, we have not discussed
Right.
it, or we haven't, but.
No, I understand that part. I was just kind of looking what they were proposing up north. And I'm just kind of sure that we've already kind of talked about it as a couple of school owners that we didn't want to go that particular route. But we will submit something. I'll make sure we all get together. That's why we've been talking this past week, and we'll get together.
And up north, one of the schools did say they didn't have a problem and wanted to audit it, but you're talking a whole big to-do thing. We don't even know if that would be anything that would be legally right for us to do. So
Okay.
that's not anything that's...
When the discussion at the northern meeting is, and a number of the board members appear to be concerned about us being too far involved in individual private businesses. That option would be, at this point, is not something we've talked about,
Okay.
but it's somebody else presenting that as a possibility. The other issue is that we're not in the auditing business. We prefer not to be, but that all depends on what the final compromises look like.
So Gwen, just from your school's point of view, and I'm not asking you to necessarily speak for the group or even in discussion with what your thing is, but the whole purpose of the surety bond is to provide some type of guarantee, if you will, for the students. So just from your point of view, how do you fix the surety bond? How do you make sure that the students have some type of guarantee, but that the availability of the surety bond is still an option for the school?
Well, for me, because we had 2 campuses, and our first campus was under the $10,000 surety bond. So when we moved to our location, we were grandfathered in. But for our second campus, we did have to have a $400,000 bond, which was like $100,000 collateral cash, $12,000 a year we paid to keep that bond going. I just think that that the amount of the bond was the problem, because it's an astronomical amount of money it's to come up with. And then that money that you pay yearly, that $12,000, you don't get that money back.
Right.
Okay, so for a surety bond, I think if the amount was lower, to make sure that the student, I don't know how many even students, but the problem is too, is that the majority of all the schools are Title IV funded. So you can't get X amount of dollar from the student anyway. So you can't, if the student has 0 to 450 hours, even with federal funded monies, you can't draw down the money unless the student has been enrolled and is at that point. Before their next disbursement, which is 450 to 900, they have to already earn that money. They have to earn those hours. You can't just base it on scheduled hours. They have to have actual hours.
Completed.
Right. So it's not like you can just have Title IV funding in your school and then you treat your cash paying students totally different. They all have to be, if you're an accredited institution, all the students have to be treated the same. So it's not like you can have cash paying students and treat them this way. You can have students that Title IV funded and treat them that way. All of them has to be under the same umbrella of the same type of payment period.
The problem the legislature had with that dialogue was that full cash paid students put all their money up front immediately. The federal funded students do not. The feds pay as you go. So the issue that the legislature was concerned is if the city only had 5 or 10% students who were not federally funded but paid this, some of them pay on a payment plan. A few of them, grandma or grandpa puts up the money and says, Sally's going to go to school, so we're going to pay it right now. Those students are at high risk for loss if the school closes during that, before those hours were earned. And that's one of the problems the legislature had with that. And that's what the reason they liked the federal funding diagram, or the approach that the federal government took on how to distribute the money out. So that's why they came to that conclusion. And that was the assembly that took that position.
And I do understand, their thinking, but really, and all actuality, the bottom line is how many people walk in the door. There are some that go and come in and they pay full cash, $18,000, $20,000 cash up front, but the majority of them, the financial aid director or person, break them out into payment periods. Even though they're cash paying students, they break them out and you pay maybe $5,000 up front, you pay $1,000 a month. They kind of normally break them out. I know at our campus, if we have cash paying students, we have to give them a projected worksheet of when the payments are going to be due and how much they have to pay a month.
So you don't accept a full pay cash student?
I've never had one.
Some schools have claimed that they do.
I've never had a full pay right up front, give me a check for $19,000, no. Not in 10 years.
I have a question that would be of the schools that I would like to know. Would there be a reason why you couldn't treat all of the students with the Title IV where you bill and you get paid? Would that hurt any of the schools? That would be my question to you guys out there as you come forward. It's just, if you're taking the Title IV, could you treat every one of your students as a Title IV student?
Well, if you have a good student and that comes to school, then you've actually earned the money. Say a student has 800 hours. They're almost, about maybe not 2/3, almost about halfway completed the program, okay? Say 850. Well, even with the NACS calculation is you're due that money. You're due, if they're 50% in their contract, you're due 100% of the monies.
So would there be, my question is, would it hurt you as a school? Is there some reason why you couldn't treat all of the students as a Title IV student in bill? And that's the part maybe I see somebody shaking their head back there. That might be the part, I'm not the one that's in the beauty business.
Right.
So my thought would be that they all be treated the same, but is that something that you could do so as you come forward, maybe you could share that with me?
Well, I think these schools probably have to speak for themselves about that one, but I would see, if you asking me, if a parent came in or a student wanted to pay, say the student wanted to pay because they're 18 years or older, and they wanted to pay cash up front, if somebody's going to give the school, to be totally honest, $5,000, $6,000, $7,000 up front, I don't see why the student couldn't the school couldn't take the payment and apply the payment towards it. If you're a school in good standings and been accredited, never had any complaints, why wouldn't you take the money? Because you know what might happen the next time around? They don't have $5,000, $6,000 to give you. Things happen where now it's not affordable anymore. They can't pay the payment that they said they were going to originally pay. That happens a lot. We have students that come in and even if the Title IV doesn't completely cover all their tuition, and they're on a payment plan, they might start out paying at $250 a month, $300 a month, or whatever payment, and down the road, maybe 5 months down the line, something that's happened drastically with maybe housing or child care. Now they can't pay $500, $600 a month. They got to pay $100.
So basically what's happening with the Title IV is you're guaranteed that money.
Not necessarily.
Their hours. If they are, let's go with 800 hours.
Okay.
Okay, and if a cash paying student has 800 hours and all of a sudden now doesn't have the cash, you're not guaranteed to get paid.
With Title IV either.
With the Title IV either?
Well, why wouldn't they have?
You only guarantee that student doesn't have the 800 hours, but the payment period is 900. Okay, so you can't disperse for 900, but if the student should have had 1100. Okay, see, we can also base it on actual. When you disperse the money, it has to be actual hours, but actually, if the student has not had perfect attendance. Say the student is at 75, 76%, okay, attendance for the last 2 evaluation periods. They're still in compliance, but they still owe more money.
But who's paying for that money under Title IV?
You don't get to get the money that they're over.
Well, the problem is the money is guaranteed if the student behaves as
Right,
the contract
right.
says. So therefore, the money is guaranteed.
Right.
As a non-paid, a full-paid student, the concern that we've heard from the northern schools in the first hearing was that if the student suddenly has a problem and decides, instead of using the money that grandma gave to her to enroll and pay for the course, instead decides to go buy a car with it, then that's what the risk for the schools are. Is that correct? Because that's what they were saying. But the money was in her hand. It was her bad decision, not the state's and not yours.
Right.
But if you had all the money at once, then she couldn't do that.
And that's how, I hate to say this, but that's what VA is getting ready to do. Instead of the veterans giving the students some money, the new law states they're going to give the money to the school. Because the schools are left a lot of times holding the bag and don't get the balance of the money.
I have a question, and I'm a realtor by trade, so
Okay.
this is where this is coming from. If a cash student came in and they gave you $18,000 to go to school, could you put that into a trust account where you set it in a bank account, where you drew the interest on it, and then every month when they went to school, take the money out of there so it was sitting over into a separate account?
You could do that.
You could do that?
Yeah, I could do that.
Now, the issue in real estate law is that if a real estate agent puts the money into trust and then closes their shop, that trust money must go back to the person who put it there, or it's a crime. They get prosecuted for that.
But
So it's a
I
different kind
understand
of
that.
thing to set
I
that.
understand the whole issue. I'm trying to be really understanding on all sides because I understand that it's about the student too. Okay, it's not just about the school owners. And I think we all feel that without the students, we don't have a school. So, it's like a trickling down effect to all of us. So, to me, I just want to do the right thing, but I want it to be where it's totally done in accordance, with the law. And I want to make sure that it's something that's livable for us all.
As far as like the board being involved, it's trying to figure out when we should begin and when we should stop. That's what this whole process is here as far as involved in the surety bond part of it and the schools themselves. It's basically, as an educator yourself, it's your job to make that student want to come back to school. And if they're just there, just to be there, which most government paid are, I mean, they're there to get an education, which sometimes is very rough. But that's what we're looking at too. And so it is up to the schools a lot of times to make that student want to come back and to continue, so you have no problems with any of the financial.
And that's what we all try to do. I mean, as school owners, I know that's most important because we do have accreditation standards too. Along with our state standards, we have accreditation standards. And they come in, I mean, those agencies come in and they go through those files with a fine-tooth comb. Okay, so it's not like you can just take this student and drag them on and drag them on and drag them on. They have to keep good academics. They have to keep good attendance. You know, and practically, you know, I mean, it's just a lot of different areas that have to be evaluated. I mean, and this works for the school, and the schools need some of this working capital. I mean, you need, all of it ties in together to run a successful school.
If I heard you correctly, you have one school that had the grandfather $10,000 bond, and you have another school that had the more contemporary $400,000 bond.
Mm-hmm.
So in the event that the surety bond, for one reason or another, as we go through this process, were to be just one flat surety bond, how would your school be able to manage that disparity instead of having one that was so low and one that was so high? If both schools had just one flat surety bond, how would your schools be able to tolerate that?
Well, I don't think we should go back to what we've already set in stone. I think what we should do is move forward, if you're asking me.
Well, that would be a moving forward decision because they're asking us to decide.
So you have to combine the schools. All schools can go under that one particular bond. So the schools that's already standing.
No, I'm proposing a what if to you.
Oh,
It's just another what if. It's just, you know, if making the decision to have a surety bond, let's just say it's $100,000, and all schools were to be compliant for just one surety bond amount, how would
I
your
think the
schools
schools
be?
that's already open and that's already been in business, that's already proven themselves, I don't think they should have to go backwards.
So you feel, when you say backwards, you're saying that a grandfathered school has already proven themselves.
Absolutely.
And that to raise the bond amount is a step backward.
Well, if we're going to have something that's going to be in place, I mean, we're putting it in place for the existing schools, or we put it in place for schools already? We're going to be changing the laws are going to be changed for all the existing schools?
That's what they're asking, right? Is that right?
So whether you're
They're
a
asking
new,
everything.
an
So that way we need
So
options.
your school that is a 10,000 and one that is 400 would now become 100,000 and 100,000.
What occurred in
This
the
scenario.
legislature, and pardon me, Madam Chair, what occurred in the legislature is they repealed the old law, which is both the $10,000 bond and the $400,000. Now they turned around and asked the board to be responsible for bringing forth a new proposal, which the legislature will approve through the legislative commission. And so what Mr. Leader is asking, how do you react to a single level bond for all schools across the board?
whether you're new, existing, multiple locations, grandfathered, not grandfathered,
So if you
just
have
one flat fixed amount.
For no matter how many campuses you
Doesn't
have.
matter.
No,
You've got
for
two,
each
you've
school.
got two bonds,
Oh.
Each school.
one for each.
I mean, I think we should have an option. Yeah, I mean, either way, but I think there should be some type of option. Okay.
Did you have a chance to look at the International Academy of Style?
Mhm.
Theirs? Because I think what they proposed is 100,000 for existing schools, 2 years or more in business, and then the new startup schools to post 200,000. What I'd like to ask the schools here is how they feel about that, because that's for a 2-year period of a $200,000 bond, and then dropping back to 100,000 after 2 years.
So what that would mean in your situation is your one school that is a $10,000 grandfathered bond would increase to, in that proposal, $100,000. And depending on the cycle of your second school at 400, depending on how long it's been in business, under this model, it would drop down to
It's
$100,000.
been over 2 years.
So then it would drop down then. So both schools would each have a $100,000 bond in that scenario. How does that work?
But you want to be totally honest with the board, and as long as all the other schools, if this is being imposed and everybody has to cooperate or, and have to comply with the same guidelines and, they're having problems and then I have to come up with my $100,000 bond and then the other schools, because they're having financial issues, they don't have to come up with theirs, then I really don't have a problem. What we come together as schools and the board or however it's decided, I'm going to voice my opinion with our school owners here, and then we'll come up with something that's comparable to what the other schools up north has came up with. I don't have a problem. I just want us to be able to see that the schools are financially sound. Because when we get a student that comes in and say, for instance, they come from another school, and I've had students to come from other schools, and the schools out of state, they transfer, they have no monies left, even with Title IV funding. We can't take them because the school's already exhausted whatever funds that student has, and that student has to wait to the next payment period, which might be 2011, 13. We can't do anything for that student. The student doesn't have the money to pay cash, so it happens with Title IV too.
Miss Annie, as far as the bonds go, that's all turned into you, am I correct?
Yes.
It is, and so you know when a school is not current?
Yes, we're notified
Okay, you're notified by the bonding company?
by the
or-
bonding company, yes.
Okay. That would basically put all of the schools on the same level. And, just because one school is in trouble and can't make their bond, then, that's definitely going to be looked at. And we're not treating any schools any differently.
What is your suggestion for a school that can't get their bond? Like, if all of a sudden I'm running my school, I've been in business 10 years, got my thing going, now all of a sudden, one reason or another, my surety bond company went out of business, and now I'm having a little trouble getting my surety bond.
So that's when we have to get something in place.
So what's your suggestion? Just off the top of your head, and what's your suggestion? How are you going to treat me at my school now that I'm
Maybe something like the Title IV situation.
So kind of a backup plan.
Right, I'm not saying to close the school or, anything like that because the students in the school owners suffer. But what I'm saying is if there's another alternative method, it's either or. I'm for either or.
What does our law say, though? Do we have a law that says we can't, what we have to do if they don't have a bond?
Okay. Actually, what your law says, Annie Curtis speaking, Chief Inspector, what your law is saying is that you need to do either, you've got to come up with a bond amount for all schools, and you also, the other side of the law is that you have to come up with a reasonable payment plan that can be adopted. Either you get the bond or you get the payment plan. Your payment plan has to fit. If you have a student that pays a full amount, it's saying that you can't take that full amount. It's actually saying you need to do increments of payments. And you brought up the proposal of put it in a trust fund. This particular law does not allow you to do trust funds. It allows you those two options.
And Ms. Andrew, do you shut the school down if they can't come up with either option?
We try not to shut the school down. That's why I think the second option is a good thing to work on, because that way you give a person that doesn't have that money up front, and all of us have hard times, it gives them another way to work out the school issue.
Madam Chair, the issue is when a school becomes to the point where they can't get a bond under the old way, the only option for us was throw all the students out, close the doors. And it takes about 4 months to get us to you and get all the legal processing done. And that was the only option we had. And so we had a couple of schools, one for sure, and one that was telling me in private that they had some problems getting a bond. that we were going to close down. And the legislature, they were held in abeyance for a short period while the legislature was processing, and we told that in open hearings that that's the condition we had, that if this law, a law wasn't passed to correct the situation, we were closing one school for sure. Period. There was no ifs, ands, or buts. With that being known, the legislature said there should be more than one route to stay solvent. And because the surety bond, because contractors are having the same problem, surety bond process required a surety bond. Those surety bond companies are saying, well, we don't want the business anymore, it's too risky for us in the recession. So the only way we can deal with this is we jack the price up so high people can't afford it, so they can't get bonds, they can't qualify. They either can't qualify because they can't afford the price, or they can't get enough liquid collateral, meaning cash, negotiable, or property that had no debt against it, as collateral that you couldn't touch anymore. Well, most of the companies, unless they were a big chain, could not afford that. So that's really what drew this to the table.
But I think too, Mr. Vance, that, and the board members, that I think the problem is really going to come in, and I think the board has to make this decision, is my concern was that the schools that are new. I mean, if you can't make your bond, and I understand that not everybody can come up with it, but when other schools have to come up with it, then, I mean, it's just, we all in the same boat. But when a school cannot be, or you look and see that they're financially sound, and the board is not active in some kind of way, that the same issue, you're going to have the same problem, because it's everybody's dream to open a school. And I share that to my students, that one day I want them to be in my position where they can own their own school. I mean, that's ultimately is a goal. But if you can't keep operational a 5,000 square foot building, plus, with the walls up, all these other expenses, and then you have students in that you're taking their money, what is it to say that you're still not going to have the same situation? So that's what one of my concerns, and it's only because I have a school that I'm actually working with in Columbus, and their laws are different. She had a $35,000 letter of credit. She opened her school last September, and now she's on the verge of folding because she can't keep her doors open and pay her rent, and the students pay her cash because there's no Title IV for her students. See, there's no Title IV for 2 years, minimum.
Well, let me ask you a question. This is hypothetical. How would you feel if a new school coming in, and I'm going to refer to Mr. Jim now after I ask this question, a new school coming in to have a surety bond issued, or I'm not sure if it can be done, or the money's needed for 2 years until they can get accredited, because you cannot get accredited until after.
Let me just explain to you why.
I'm not sure that that can be done.
No, the accrediting process is a qualifier process. It's a lot like a loan qualifier. NACAS has no authority to dictate anything. They operate under the federal law and are dictated to use a particular standard to qualify the schools, and a minimum standard is they have to be in operation and financially sound for a minimum of 2 years. Doesn't mean they'll get it after 2 years.
Right.
Could mean 3, 4, 5. The second issue is the day they open up, they may very well be financially sound. But what occurred during the recession was land that was put up as collateral was halved at best in value. So what used to be a very financially solvent situation is now underwater. And so they no longer qualify, so the bonding companies won't put it up anymore because they can't get their money back should it collapse for any reason. So that's the two issues of court. The other thing is this law was specifically stated, the intent of the law, that the legislators spearheaded, was they did not want to close schools if they at all possible could avoid that. And the only option we had before was to take their license away. The second option they offered up is another way to do business at the school's choice. If they're financially sound, they can get a bond. If they prefer not to get a bond, they have this other collection procedure that allows them to continue to survive and maintain jobs and teaching students. What we ran into with the biggest heartbreak is when a school closes and has, say, a $10,000 bond or allows their bond to lapse. And that's the normal way a business going under does. The history shows the bonding companies will see the bond lapse. We get notified 3, 4, 5 days, a week later. Too late, money's gone. There's no way to do anything with it. So the legislature understood the issue that we were struggling with. The problem now is they say we still would like 2 avenues. One, the bond, whatever the bond board thinks is an appropriate number. And then the school, like Ms. Bramo would like to do, if she likes the bond and can afford it, fine. If not, she uses this other technique that still stays alive and solvent. The schools have expressed concern about underfunded schools. Now, what we see on the front end is, well, we only can review their financials during the initial licensing procedure. We don't have any authority afterwards to go back and say we want to see your books and all that. Most of the schools are pretty sound when they go in the door. A year later, 6 months later, some partner drops out, so their economic strength drops with them. Or they get sued for $2 or $3 million on something, and they get an award against them. And now they no longer have the liquid capital to survive. So those are the realities of the world. And so that's what we're having to deal with. And the legislature's alternative in the law itself, and they passed the law, so we're stuck with it, is that we need to do 2 routes. Now, the impact that we're hearing from the schools is they're acceptable to a bond of some type. The number is what we're really arguing about. And some alternatives might be, to the bond, is that it lasts for 2 years at a certain level and it drops to another level later. So those are the kind of decisions you'll have on that. On the other side of the equation, for the formula, we adopted, or at least discussed and said we would be willing to use the federal approach to funding because that seems to be working nationally. So that's the only reason. But they didn't hold our feet to the fire. It had to be exactly like it, but something similar that's reasonable that the board could accept.
Well, too, that we can't foresee any. I mean, everybody in here could have a problem. You could have a problem in 2-3 months. All of a sudden,
So what's going to happen?
and everything taken out from underneath of you.
Right.
They're left high and dry with nothing.
Has it been easy for you to seek a surety bond as a school owner? I mean, I certainly don't want to put her on the spot. I'm going to, hopefully, as other school owners, you'll all have the opportunity to answer some of these questions, even if they're not directly asked of you. But just as a school owner, is it easy?
I think
to
it's
get
the
that?
bond amount. The bond amount, I mean, $400,000, I mean, it takes an astronomical amount of either, pretty much the insurance companies want cash. Okay, they don't really want, like, the land, the properties and all that stuff because of the value that it has went down, tremendously. But I think a bond of some amount, even if the new schools, old schools, I mean, some amount for a bonding, or if you've been in business for X amount of years, and then maybe your bond is this, and if you haven't been in business, maybe the bond is that, because it could happen to any one of us, but the majority of the schools that's pretty much sound, pretty much they're already sound with the federal government, because really, Vince, to be honest, board members, every school wants Title IV funding. I mean, let's just be honest.
So accreditation is a goal for the schools?
Absolutely.
Is it ever not a goal for the schools to be accredited?
That's the goal.
It is the goal. And so in accreditation, how many students do you have that are actually then cash pay?
This could be maybe 10%, 10, 15%,
So 10%, if they're 20,000.
something like that.
And so how many students do you have altogether?
Well, if you have, say, 150 students, 200 students, and then maybe
20. So if you have 20 students that are paying cash, and the education is 20,000, there's 400,000 for you right there. I mean, that's why there is a $400,000 bond.
yeah, but you're not going to get 20 students paying cash in one time.
Well, but you're saying that, and the potential is there. The potential is to have that because it's 10% of your students.
Mr. Leader, what I've been hearing from the school, it's anecdotal at best, is that real cash full paid students could be as low as 2 or 3, 5%. The other cash paid students pay on payment plan of some type.
Right.
So but under the qualification regulations under U.S. Title 34, it requires 10% of your students have to be cash paying, I think. So that's a minimum number that they have to
make
have.
payments.
Whether they make payments, $20 a week, or the whole amount at once, they have to be cash paid. They're not federally funded students.
And they're not full pay.
They're not.
They're just cash
As long as
pay.
they're paying cash on their books.
So maybe you should hear from some of the other, because there's a couple other school owners here too.
You're very informative. I'm glad that you stepped up. That's really nice.
So you have a better understanding now of the business.
Is there anyone else that would like to come forward?
Yeah, I would. I'm not a school owner, but I still would. Because I have a couple of questions.
Please give your name and where you work.
My name is Gail Moore, and I'm with Expertise Cosmetology, North Las Vegas. And I'm going to start out with the last statement you made about 10% having to be cash pay. That's your 90-10 rule, but it does not mean tuition only. It means any funds we bring in by clinic, any other funds, folk rehab, veterans, clinic, 10% is not only tuition. So if you've got a good clinic, that counts to get you 90-10 rule. So it's not tuition only.
But the issue is not to establish that there is a standard you have to meet.
But if you said tuition, it's not tuition only. That's
No,
my
I
point.
didn't say, I just said cash paying student. Now,
Right.
if somebody is paying for the cash paying students, it might be Veterans Administration, it might be the county welfare system who decided to sponsor. We even have an agency within this building that pays front-end costs for certain kinds of job training. But I'm not saying that, but what they're saying is they're not going to all be federally funded programs. It can't be 100% federally funded. There is a standard to meet. That's all I'm implying.
Right, but the 90-10 rule is cash coming into the school.
So
It
when
is
you-
not tuition only.
When you say clinic, does that mean customers?
Yes.
Okay.
So that's my point. It is not tuition only. I don't care where you get it from.
Madam Chairman, just so that the board understands, I'm a retired teacher, and I also enrolled students. I also got funding, ran the office. So what I want to make sure you understand is that tuition and student payments are not the only revenue. After 250 hours, the students leave the freshman room, go onto the floor, and now the school is making retail from shampoo sets, colors, nails. So there's a second piece to the retail and the income to the school. I don't think you're aware of that. So it's not just
Right, it's not
right,
just
there is a
tuition,
second
right, it's any
piece
cash
of income that we're not been mentioned yet.
And that cash is in the 10%.
That cash is part revenue.
Right, that's part of the
that
10%.
student
That's part of
earns
the
in school.
90-10 rule.
Some schools reduce tuition based on the income that student's going to provide. Some schools do not. So there's two forms of revenue to the school.
I wanted to kind of get back to what I believe Chairman Ditzler was alluding to, which was if in the first 2 years of a school, the bond was a certain amount, and then through the goal of accreditation that happens after the second year, if I'm to understand, and if I was hearing you correctly, there was a proposal that would now your surety bond would drop according to the way, in favor of the way that you collect on your accredited students. Would a proposal like that work out for the schools? Did I make myself clear? In other words, as a new school, you would have a bond, but then as you were accredited, your bond would go away, but you would only be able to collect your student fees according to your accreditation scenario. So in other words, you would never be pre-collecting these cash pay students. Is something like that a possibility?
Can I comment on that? Because
Is
of
that
the
No.
because of the way that the refund calc, say a student comes in from 0 0, and their first disbursement should be 450.
Right.
Okay, they've already probably clocked, because it's based on scheduled hours versus clocked hours. They are probably between 30 and 40% of their contract.
Completed.
Completed. Scheduled hours. Has nothing to do with completed. Scheduled. That's the way the refund calcs are made. So if a student, a cash paying student, is only giving so many every quarter, at that quarter, they're going to owe more than they can pay.
But I thought you could also collect after 30 days. If it was either 0 to 450 hours or 30 days.
No. No. The Title IV funding, your grants, your PAL, is a 450-hour, 30 days you can collect on your first loan, your federal loan disbursement.
So it's 30 days or 450 hours.
Exactly, depending on what kind of funding you're pulling in from the student. But then you may have students that only get grants because they don't want to pay any loans. So then they sign a promissory note for what their loans are worth, they want to pay cash. But a 450-hour disbursement will not cover that first 150 hours. They're going
Mr.
to
General, I do have a question because on the Title IV funding, everybody that comes up here has a different scenario of what their school is and what they take in and what the hours are, because I believe you were told that.
That was what we were told at Reno.
Right.
Or
And
north.
so I'm trying, that it makes it difficult for us to understand when each school is telling us that the pay is different at different increments at different times.
Madam Chair, the first thing is the schools have options and they choose how to deal with the federal government. And the federal government will go either way. And it depends on who the owner of the school is and which option they choose. Example, one school in Reno doesn't take any money until they reach the 25% bracket. Another school says, we take it from the front end. Right? And so those are two different payments. But there's also a lot of intricacies in the federal funding. And as you know, that I sit on the partnership review committee of the U.S. Department of Education for the Western States, that they complain all the time that a lot of schools don't know what the hell they're doing when they deal with it. And so they have problems. Luckily, our schools have been okay in that area. So we're very proud of how well the schools have functioned. But it's not a simple, real simple formula. There's a lot of percentages, a lot of things that can be done. So there's no one clear answer to it.
So when we offer them an option of a couple of different things in the law, it should basically be the same.
We don't want to get into the complexity of the federal law because it is like the tax code. It goes on and on. What we're looking at is some simple process.
My name is Sandy Dunham from the Academy of Hair Design. I have a question. We're talking Title IV funds here, which not all schools probably are even Title IV eligible. And for those, so a new school would obviously not be Title IV eligible. For those of us that are Title IV eligible and into the programs, what if we lose our Title IV funds?
Right.
I mean, there's no guarantee that I'm going to have those funds next year.
Right.
That's
Do you have to file for them every year?
Well, you have to meet the standards.
And they come in and audit every year? And
Every year we pay for audits.
Yeah, an example
Big money.
is if they don't qualify, the feds will not write checks to them anymore. So what she's bringing up is the issue is even though they're a Title IV school, recession gets worse and worse, or something happens, and the feds decide to change the rules, they lose federal funding. They would have to still figure out how are we going to stay alive.
And so
if you, I'm sorry.
no, I was.
If you have another option other than that, if that's used, that would be okay with you. In
Well,
other
I
words, if
don't
you have a
think we
couple
should
of
base
options.
everything on Title IV funds.
Well,
That's what I'm
Because
saying.
you're just using it as an example.
Example.
That's all they're
Right.
discussing at this point.
Yeah.
Vince, am I under the impression, do I understand this correctly, that at our national conference, one of the issues last year was the fact that the federal government was considering taking away funds from the cosmetology program because of the guarantee guaranteed job ratio after school?
Yeah,
Do you remember that conversation?
there was regulations, and I don't know what
Gainful employment.
Gainful employment.
Yeah,
We're always
That's it.
getting,
But it's in 2015, I believe.
Right,
it
'cause
comes
that's
into
another,
effect.
that's another thing that impacts today.
we're
the
always
answer to
getting
your
tracked.
question was yes. The issue for our state was the feds wanted to use in cosmetology a 1,600-hour base. And the states like Utah and Nevada are 18 and 2,000 hours, and they said the gainful employment definition was that you're not going to make enough money to justify us paying for 1,800 hours. And the problem with that is they were using IRS records of what people
Yeah,
claim,
that's right.
who are, we all know, are not claiming all of their tips and other revenues
Yeah,
as
sure.
part of their income tax commitment. So that's the complexity. I think that passed. Some of it passed, but I don't know what the resolution was.
Gwen Ramo. It's not just cosmetology.
There's a lot
It
of
was all trades.
Yeah.
It's a different type of trade schools. So what they passed a law similar to something like July 1st, it went into effect. And in 2013, the trade schools were going to start being evaluated to make sure that they are meeting those new standards. And then by 2015 is when they'll be making the decision about the schools and the Title IV funds. But they want to just be able to make sure that the students are going to be able to pay those student loans back. See, that's just the bottom line.
Yeah.
Sandy,
Again, it's the same thing as the students are held accountable for the loans. And that's why the regulations about when they disperse the money are implied, because they're concerned that the schools collect the money and the students quit or go elsewhere, leaves them holding the bag.
Yeah.
But on the other hand of the equation is the students are committed for a certain amount of loans. If they get the training, they're stuck with that bill forever. So that's the dialogue that's going on. Next.
Sandy, you brought up an interesting point, which is one that I want to get back to, is that you indicated that there is a risk for the licensed school to lose their Title IV funding.
Yeah.
That might be a precursor to the school not being able to stay successfully open. I would imagine that that's kind of the first step to a declining school. So again, where are you going to put the guarantee back to the prepaid students? If now you have a school that loses its Title IV funding, now all of a sudden, I don't want any prepaid students going to that school. Do you see what I'm kind of saying? Because now,
And if they don't have Title IV funds, how will they stay solvent? They don't have
Right.
And if you put it in an escrow account, it's not usable money. How are you going to pay your overhead? How are you going to pay your instructors? So there's got to be some kind of leeway that the money has to go back into the school to be recycled to keep the school open.
but now,
If they haven't earned the hours,
That's
then
right.
you shouldn't be having them on.
you shouldn't be using it as a cash flow management tool anyway, because the hours haven't been completed. Right?
Excuse me, but these people have scheduled hours, and there should be some accountability on the student to hold those hours, because there's only a limited amount of seating in each school. They're limited to their incomes to that anyway. And in addition to the income that they bring in from their, rod and roller sets that are $2 per, it's not really going to cover any kind of demand that they're talking about.
So there has
So
to be
we have
some
to
kind
protect
of-
the schools as well, because they're the only vehicle that we have to generate new hairdressers or whatever. The challenge I'm hearing is we're going to put these huge surety bonds on schools, which is not effective. We have, this Title IV funding is a great program. I don't know, I've seen it in all the colleges. They drop out, buy cars, party their brains out, and then they are left with nothing. So I personally think schools have more accountability. And if there's scheduled hours and those students cannot hold up to those scheduled hours, those schools are entitled to that money. I'm sorry, but that is not right.
Are you currently entitled to them then? Like current?
Yes, we are
You are.
entitled to it.
And we should
We can't
count
always
that way.
I have, I like to say, I think we've kind of got off track because I think Title IV is not really going to be any part of this, and so we probably should get back on the surety bond and how we can resolve this issue.
Well, I
Oh,
think
wait a
it kind
minute.
of is.
We're taking input. We're not talking
Oh,
about
I,
alternatives.
it's just either
We can't
or
be
both
discussing
is what the question is at this point.
Okay, I was just wanting to maybe more information on how to solve the surety bond problem.
I would like to clarify something. When I said that the students had earned, you had not earned to a certain amount for a quarter that is scheduled or whatever. That's what I'm trying to clarify here. It had nothing to do with, I am for the schools as much as I am for the students, but there's a responsibility on both ends. And I don't feel that if a student pays you that $18,000 or $20,000 up front, you should be able to take that money and use it for overhead when they haven't basically even used half of their, done half of their hours.
Or any, for that matter.
But that's the minute they clock their 20% into the contract. That's what you have to understand. 20% they're entitled, the school is entitled to 20% the minute they clock that first hour. So we have.
So contractually.
Contractually, we're entitled.
That's all well and fine. But I'm talking about a full tuition of $18,000 to $20,000.
I think once you sign that contract, those students should be accountable for that contract. Unless
But the
medical or
legislature is asking us to
Let me
give.
clarify something. That's a legal contract. We're now adding another guarantee on top of a legal contract that really shouldn't be there, to be honest with you, philosophically.
Your contract?
The contract is between the school and the individual student. So I can understand their need, say, if you sign a deal to buy a car, when we deliver the car to you, you're stuck with a loan now. That's how the schools feel about those contracts. The issue is in Title IV funding, they have done something to make that more protection of the monies, not the students or the school, but the monies that are being handed out is what they're protecting. And so the issue is everybody's got a dog in this hunt, and each is protecting their side of their dog. The issue for us is that, as you recall the dialogue before the board a number of months ago, should we be in the surety bond issue, period? Because it's already a legal system to deal with all of that.
Right.
Now we're adding the goodwill of the legislature on top of it that says, well, we need to protect the students more. Not the schools. They never said that.
Right.
They said the students. And so what I'm transmitting to you is the legislature's opinion on what needs to be worked upon. And the issue, we have a lot of interest in certain configuration and designs of how business operates versus many of those decisions that we hear are business decisions. It's because that's how they're designed. And it's difficult to make changes in the design. But the board's charge is, if there is a surety bond, and the legislature said there will be, how much? And then there should be another way to operate without the bond. And the way the feds do it, and that's what the legislature told us, is the way the feds do it in general is okay with us. Now, so now we have to do those two options. I think talking about any other realm is out of line for this discussion because we don't have the authority to do any of those things. So that's one of the problems I'm having with the dialogue.
I personally don't think it's the board's business what you do in your schools, as long as you're abiding by the laws that they're your contracts, they're not our contracts. I think if we don't have the schools, there aren't any students. If there aren't any students, there aren't any bonds. There's nothing. So, it's kind of a bad position for us to be into because we've been told to do this. So that's why we're here. We want to know what you want. And I know that you're trying to protect your students also. So we just all got to work together here and figure it out.
Well, we also do have a law, NRS 644.403, unconscionable contracts with students. That protects them in that aspect.
Yeah, what we do is we review the contract format. We review it with the Attorney General's office and says, is this document legally binding in effect? Does it treat both parties with respect and dignity, and no one's getting the best being taken advantage of? And all the contracts that the schools use now are both federally acceptable and locally acceptable in the state. So I don't have any trouble with the contract. The unconscionable contract, we've seen a few of those, and we've made them change it, where they put requirements that aren't even authorized under the law. They're not even allowed to do that, and they're charging students for fees in those areas. So we think that That's a legal contract. And that alone is binding, and the courts have upheld those contracts over and over and over. When the students didn't get what they were supposed to get by contract, the judges have awarded them return fees, even against bankrupt companies. The trouble is getting the money once people. I was owed $90,000 for a previous job I had, and I got awarded by the court, no problem. Couldn't get it. Why? Because they didn't have any money. And so those are the problems you run into.
That's years ago, because I've been doing this a long time. We had teach-out agreements with other schools, so that if a school did go down, the other schools had a teach-out agreement, and they all had it. And we had a lot of schools go down way back. And we had teach-out agreements.
It's required by federal law.
Well, then, if we do the teach-out, and they have to give back the money to the student, then shouldn't the other school be required or be entitled to that?
They don't give back the money. What happens is,
But you're saying it could be awarded back to the student.
the Academy of Hair Design took students from another school that closed because it was federally funded school. People decided to just retire, call it quits.
Right.
And those students transferred with very little trouble. Probably you took them at a loss.
Oh, big loss.
Yeah. Because the teach-out agreement is the way you transfer students.
I know.
And that law still stays in effect. But if nobody accepts the teach-out, that's a voluntary issue.
Well, maybe that shouldn't be an option.
Well,
And
that's
keep
federal
bonds.
law. We can't change that. We can't option it. Teach-out agreements are required under the federally funded programs. But you don't have to accept it. If your school doesn't want it, you say no. It's all done. If all the schools in the state say no, you're out of luck. Then it's a civil matter, and it becomes a judicial matter in the courts. So those requirements are still in place.
Okay.
But non-funded, for example, destinations and advanced, they're in the process, they're all trying to get accredited. They don't have teach-out agreements. They can't move their students automatically, and the only thing we can do is audit the records, the hours, give them credit for the records, the hours for the students that are paid for. The school, if it hasn't been paid for all the hours that have been taught, have a right to hold up the hours. So those students can get the hours so they pay up. We do that now. The issue really here today is what's a reasonable amount of surety bond if we have one. The state didn't want to repeal it in totality. So that's where we are. What's the number? And the other is the federal design will give us some direction. The northern schools gave us what they thought might be the direction to follow. We haven't seen anything here, but we're open to that, and if you can get it together right away, we really appreciate it, because we're going to have to then start making decisions on it.
Okay, I guess I'm just going to say one more thing. If the other schools do not legally have to take the teach-out, I have one quote. Why do we want to get rid of the bond totally? Because if they can't pay for the bond, they don't have any money. They don't have any money, they can't keep the school open. If they can't keep the school open, the students are going to be out there.
Well, what occurs is the bonds are allowed to lapse before they close the doors. So there is no bond, even though the law requires it. And the resolution to having no bond is taking your license. That's it. That's the only resolution we have.
Well, you know what, I hate to say
So
this, but I think it's the only
it doesn't
resolution.
work.
Because if we allow to keep them in business, if they have no bond and they can't get a bond, they have no money. Which means if we have to start putting money in escrow and only dispersing it at a certain time, these schools are still going to go under. The students are going to be deeper in debt. The school is still not going to get their money, and the student still isn't going to get their education. Bottom
Right,
line.
your
Bottom
legislature.
Bottom line. It's like buying a car and you can't put gas in it.
Thank you.
Anybody else have any
Sandy,
proposals?
would you mind if you offered because you're a school owner, and you had some really nice things to say, where are you kind of at with this discussion in terms of the bond or reducement, or where
Well, I'm more in favor of the bond than restricting how tuition's collected.
Okay.
First of all, I want to know who's going to monitor it. Are we going to have to pay for yet another audit?
Right.
When we already have 2 audits every year annually, and once you're accredited. So it seemed the simplest, safest way to me is to have the bond. Why does this board want, I don't think the board wants to worry about how we collect our tuition or if we collect our tuition.
And how easy has it been for you to
Well,
get
I've
your
been
bond?
in business since before you were born, so I wanted to do it. I have a small bond. I haven't tried to get a larger bond, but I understand it is difficult.
Have you stayed with your same bonding company, or have you mixed it up and
I
changed
think
them?
I'd probably run with it.
Have you had to
I think
research?
we've done with the same company, they just renew it every year, so I mean, they don't.
And so we've heard up in the north that some bonding companies just simply aren't issuing this type of bond for schools any longer, and so they are having to go to a different bonding company. But that's not been your experience?
No, I've not had any
But
issue.
the issue is 10,000 versus
Yeah.
100.
Yeah, right. And so in the event that the decision comes down that the bond is a flat fee just for all the schools, how would that affect your particular situation?
Well, I would have to raise money, obviously, it's not going to be down to $10,000.
And so,
I would think that a brand new school, but I would like to see, a brand new school bond should probably be higher. They're at a little higher risk than it exists once you've been in business 2 to 5 years, even up to 5 years.
so I want to remind you, Sandy, that the 3 schools that went under last year or prior years were all well-established schools.
So
One, I
there's
think,
no
was over
guarantee.
10 years. I think it has been in business over 10 years.
So all businesses, I mean, you drive down the street, it doesn't matter anymore.
So, but yet you wanted to see
Oh, because
the
it's a
newer
new
schools.
school. Well, because I think when they start up a new school, they need to know that it's a pretty costly operation to run.
So maybe a little higher risk for the newer schools, but
I personally think it's a little higher risk for a new school.
So what I'm hearing you say, Sandy, is
Higher bond.
a higher bond for a new school to qualify for 2, 3, whatever it is. And then after a certain period that they're showing stability in, then you drop them to a
You
lower.
get a lower bond.
like 2 to 5 years.
That's retirement, it would be out there.
On-
And I
on-
wouldn't get involved.
Is there any
Do we
other?
have to give them I'm not sure if the legislature wanted us to give them an option. Is that something, in other words, if they don't want to do the bond, they can do something else?
Yeah, the
That's what
legislature
the other-
clearly.
They say you have to do that?
Yeah, the legislature said they want us to relook at the bond number to be something reasonable, to imply, significantly implied a lesser bond. But then they said we want another way for those schools that we would have an alternative, but to close them otherwise.
So would it be an either or then?
That's correct.
Well,
And it would be
California,
your choice.
it would be the school's choice.
Yeah.
California has what they call that tuition recovery. But now, I'm not sure, I don't know how many schools have closed and how that's affected a closure. Since they've had that, that's been an
But
operation
now,
several
if a
years
school
now.
chooses to take the bond, let's say the $100,000 bond, they're accredited school and they're doing the $100,000 bond, and they want to, can they take a cash paying student and take their full tuition?
Yes.
Yeah.
The way the legislature structured it said, if you want to produce the bond, you operate like you are now.
Okay,
Okay.
so on
And if
this
you can't
where
do that, or refuse to do that, or you can't qualify for the bond for whatever recessionary reasons there are, you have this alternative method to stay alive.
But Vince, how is that going to be monitored? Should I decide, okay, I don't want to pay a bond, I'm going to collect my tuition quarterly or however? How are you going to monitor, how is the board going to monitor that? If a student comes in and wants to pay cash, how are you going to monitor whether he took that cash or he took 25% or whatever?
That is yet to be decided.
That'd
I mean,
have to be
that's gonna be
strategized.
another-
Yeah, the regulation might have to include in those cases that the board has the authority to inspect the records, and if and when the records are deemed to be questionable, that, from my view, we would hire an outside audit firm to come in and to look at it at your cost.
At the school's cost?
Yeah.
But, so most of what's being said, and I would say that most of the schools from the few that would take the bond. Because in that way, they have control of
Unless they
everything.
come to
And it sounds like but it sounded like a reduced bond because the 400 was a little excessive.
surety bonds are getting tougher to get, not just for everybody. What happens if you can no longer get that bond?
Then that's the alternative payment plan. It allows you to make a business decision that says, I can't qualify for the bond.
Where there's no bonding companies that will
No
do that.
company will qualify me because I don't have enough free liquid assets. But I'm still solvent functioning in the school. I have this other ability that says the state will allow me to continue without the bond if I use this format. What Sandy's bringing up is how do we monitor that? And what I'm saying is we would have the authority and the regulation that said we would be able to come in and spot check, just like we do ours. Spot check files to see how you're collecting your funds. And if we don't have enough expertise that says we found a few anomalies and we don't understand it, we would then have the authority to hire an outside firm to come and audit the records. So that, and I don't see that very frequent, to be honest with you, but that's a guess at this point.
Well, if that brings up a whole nother thing. If it's not an accredited school and they can't get a bond and they're taking in the monies, as I was going to say, if it's an accredited school, then we could ask them to send their
That may be an
audit, a copy of their audit to us if we think that it's not.
If they're not accredited?
If they are accredited and they've decided to not do the bond.
Oh, yeah, I think those audits are.
And that way you wouldn't have to pay for an extra one. But what I'm looking at, that brings up another question. If it's not an accredited school, and how are we going to regulate it? Are we just going to go in and...
We'd have to decide how to treat everyone equally and fairly. That's the most important. The issue with the NACIS audits may or may not fit the needs of this agency. They are doing the accreditation audit based on federal law. The only thing they require from the state is that the agency who's accredited continue to be compliant with state law. So if they're required to have a bond, and they have a bond, in their case, they have a $10,000 bond, they're in compliance. Now, a new school, and there's a couple of new schools, Paul Mitchell, whatever, they have to have a $400,000 bond for them to be compliant with NACIS's regulation, inspection. So the law hasn't changed. We still control that law. It's just that NACIS says you're compliant, you got 10, if you qualify for 10. You're compliant with 400 if you qualify for 400. So that's a dilemma.
Well,
And the NACIS audits, I don't know what they do, if it relates to the same thing, to the issue that we're bringing up here.
if a school is not accredited, can we ask that they have an audit done?
Well, we don't have any
It's
authority at this
an
point.
annual thing with...
It's with the Department of Education, and it has to be like GAP standards. So it has to be federal, not NACA standards, the
That's federal.
Department of Federal Education standards. I mean, that audit has to go through GAPs.
But I think what Mr. Jimno is saying is that the same audited report may work well for NACIS, but it may not work well for what our needs are.
Yeah, our audit would
Right.
be for
Right.
how you're taking your money in.
Right.
NACIS report may or may not have it in the way we
Yeah.
would be able to determine that.
Right.
I don't know, because I don't know the audit.
Is it Gail?
Yes.
You had a question?
Oh, I forgot what it was.
Is there any other input on this particular issue? I mean, we've heard pretty much the same dialogue that's been on it.
I do have a question.
Your name?
Jan Garrett D. Simone, and I actually work for our public high school, for the Clark High School District. So I'm a little out of the realm that they are all faced with. But I hate to see government tell someone that you cannot have a cash pay, because it's kind of like buyer beware. I can go buy a car on a payment plan. I could go buy a car and give you $70,000 cash, walk off the lot, my car's now worth $40 because of Blue Book, right? So I hate to see government tell someone who is a business owner, sorry, but you can no longer have a cash pay. But has anyone really looked at the number? Because I'm hearing like maybe 2% or cash pay. So what does that number really amount to? Are we talking 40,000 per school? Are we talking 80,000 per school? At what risk here is the individual student? I mean, how many students are really at risk at any given point? And maybe the bond should be based on that number.
Yeah, and I've asked that question of every school, and every school gives me a different answer.
But there's got to be an average.
Because there
I
isn't
mean,
a lot.
everyone sitting here though
But
says
that's
2 to
just very
3%.
The motivation is not the cash pay as much as they want. Some of the schools want to use the front-end cash pay to finance their operation on the front end before delivery of service, i.e. buy pencils, paper, supplies, and things like that. And that's a philosophical position, that's a business decision they made. Other schools say we don't do that. So that number is all over the board.
But where do those other schools put that money? That you're guaranteed that money really is there in an operating account?
I don't understand. Say it again.
Well, you said that some schools use it on the front end,
That's
on a
correct.
cash pay for operations.
That's correct.
Others say we don't do that. So those who say we don't do that, where are they placing that money?
Just sits in their operating
It
budget.
just fits in their operating.
Do we know that for certain, or do we just believe that that's
Well,
what?
they're not
Yes.
required to maintain a trust.
That's what they're telling us.
Yeah.
Right, it's a trust factor, though, is my point.
No, it's not necessarily in a trust account. It's part of their general
No, it's
fund.
a trust factor. I could tell you, as school owner A, I use that money up front to buy a lot of products so that I know for 6 months out I have product on my shelf. This school owner B says, oh, no. I don't do that. I only use a percentage of that upfront money for supplies. So I'm saying, how do you know that school owner B really isn't using that money upfront?
Jen, the
It's a
issue-
trust factor, that's
the
all.
issue, that's a business decision.
Correct.
And the legislature doesn't want the students the front-end money that there's no guarantee they'll get it back.
So really the option then that the legislator would like is no cash pay. Is that correct?
Not
Is that kind of what they
necessarily.
would like to see though?
They didn't want to do that, go that far.
Well, yeah.
But what they had trouble with is this board finally came to grips that the surety bond issue is cosmetic in nature and not really working. And we wanted to repeal the entire requirement. Everybody would be treated fairly as a business. The trouble is the legislature didn't want to do that. There's this feeling that we need to do something. We don't know what, but we want to do something. We can't make the call, so you guys get stuck with it. That's what occurred. Now the issue with the cash pay, some of the schools violently opposed getting rid of that requirement. Because, so you ask them, why do you oppose it? Well, it makes our books easier to manage. That's a business decision. That's not, when I was in a software business, I had to make all these decisions personally. That was my decision, because we didn't survive, period, otherwise. So the issues are getting business decisions off the table and talk about what the legislator's message to us was. That is, the students have too much exposure, there's too much protection for the schools. That was the message. Somewhere in the middle is reality, and the board has got stuck with the dirty work of having to figure that out. So that's why we're doing the input, is trying to figure out what you guys think to help balance the other messages we've seen. So that's where we are. So
Plus, I think whatever we put in place, whatever we decide, the board decides, it has to be something that can be monitored.
yes, that's right. We have to figure out some alternative monitoring systems.
Well, and it also has to be doable, Sandy. I mean, we can make a decision as a board, even using the input. But if all of a sudden that decision, let's just say that the decision is to keep the $400,000 bond. Well, if companies aren't offering it and schools can't qualify for it, well, then that decision is going to have to be modified again anyway. So it does have to be a workable solution all the way around for the student, for the schools, and for the board's monitoring.
Madam Chair, can I recommend maybe a 5-minute break for people to hit the restroom?
Yeah.
Is there anything on this topic? Can we move on to the other 3 topics, which I think will go very
that's what I was trying to do.
I think what we can do is we can get together, the school owners, I see two more down there. We can just, within this week, and then we can send our recommendations to Ms.
So you send out the proposal for us?
Yeah. We already had something already kind of in mind that we had discussed, but we wanted to wait until the meeting today to see what was already on the table.
Madam Chair, I have just a real quick question for all the school owners. For your suggestion or recommendation to the board, if you can just let us know what the percentage of actual cash pay, because I think that's just really the only question for the bond, and then we can make a decision. That's what's required of us from the legislature.
Right now.
Yeah, that
Did you
is.
say maybe, an average school has 100 students? Am I there?
So you have to clarify exactly how you're identifying a cash-based student.
Prepaid.
Prepaid.
Like their
Yeah,
entire
cash pay.
tuition.
Does cash pay could be a payment program versus walk in, here's 20,000 versus 2,000 down payments.
People who can
They're both cash pay students, so if you need to clarify that to be prepaid.
Prepay is what I was.
Well, Mr. Jimno, they identified that student up in the northern as there's 5 different types of students, and that was the large advanced paid student, the large amount advanced paid student.
Yeah, those
So not a pay-as-you-go, because a pay-as-you-go, once the school closes, there's no more payment due or no refund due.
It could be a week.
I'll give you our numbers right now. That's that's zero. I mean, somebody walking in with a $20,000 check is just not happening.
Well, so Mr. Jimbo, this brings up an interesting point, is that if it turns out that there's 5 students that are affected, and we've gone through all this public.
Well, let me put it this way. In the last school that closed, there was 37 students that closed. 2.5 got money back. The other 34 and a half did not, and they were owed a lot of money.
So do you see the dilemma? That's the dilemma.
So what it sounds
So
like.
what if we said that 10%
Well, that's
of 100 students?
No, I was talking about like the cash pay, because with our accreditation agency, when Gail clarified it, it was like revenue from the clinic
Right.
and all that.
We're trying to get a number here, and so if we have 100 students in your schools on an average,
So you say you have 100 students, you might have a couple cash pay, but they're making payments.
No, we're talking prepaid.
We're talking about prepaid up front.
What percent?
I said earlier, nothing. I have, you might get 100 or 10,000.
okay.
Get into the details, it's all. But some of the students were owed as much as $8,000 apiece, 7,000, 3,500. These are not small numbers when you're a young 19-year-old trying to go into schools, and you've paid that much in advance, and you get nothing back. Now, the schools that are federally funded, they're dictated by this payment plan, so there's no way that they can have a big exposure. They may have signed a contract for something, and the schools may have some liability versus they only did 250, but they need 450, so the feds won't give them the money. That kind of exposure, that's the school exposure. The students, though, that paid in advance for chunks, and the school closes just after they paid the thing, and we had a number of students that were signed up that week when they closed the doors. And those people had to put up $5,000, $6,000 up front. So those are the kind of issues we deal with. Just because your school doesn't do that doesn't mean the industry itself doesn't get involved in those kind of practices. So, and your school is federally state funded, so there is no liability to the students other than the program's closing down.
Correct. I just wondered what that actual number of prepaid students was. Because that should drive the bond amount. So that if every school says we usually go between 1% and 2% prepaid, and our average tuition is $18,000, then you would know that every school should have enough to cover, based on 100 students.
And that number is around 200 to 300,000.
That's the.
I've already run those numbers several different ways, different times. different categories. What if you have 100 students? What if you have 200? What's the liability? Open liability. None of it is clean. You don't get a full student at 18,000. What you get them is somewhere in the middle. The school closes their 80%, 70%, 30%. So you have to run actuarials on a student base. But the numbers always come out 200,000, 300,000. If it's a full school, but most of them, an example, the schools would close would probably been less than that. Somewhere in the 150,000 would have probably covered most of the
I think we're going to take a short break.
Thanks.
Bring this meeting back to order. I think that once the schools and everything have gotten together and citizen proposals, we'll be able to, look at more at what you were looking at. So I'm going to, again, turn this over to Mr. Gamble to move forward.
Pardon my cough. I got over a cold, but it won't leave this part of my throat. Hangs in there. My apologies for that. The other three items we need to talk about are pretty straightforward, and I think we'll probably cover them pretty fast. The first one that we should probably deal with is the hair braiding and hair braiding establishment. What we're doing is, when hair braiding was passed, there was a requirement for us to do some basic healthcare type of regulations. And I mean, they're really basic. And so the regulations that we're looking at are not formal, are not informed yet. But if you look on the second document, there's a list of the items that we're considering that would fit into the normal structure that we have for all other licenses. That would be treating the hair braiding license in a similar fashion. And for those who might be aware that we're in the process of pulling together the test procedures, we will be taking, Ms. Alexander, when did we decide the other day to take applications for hair braiders?
We're going to start the first week of October.
First week of October. And that means that the test is already prepared. It has been, it's an NIC test on hair braiding, and it's using their, my understanding is it uses their chapter in the Milady textbook that has been recently published and sent out for the Bible. They will be required at this point to take the hair braiding written examination based on the Milady chapter and a practical examination, and that the law test will not be implanted into the system until the new RFP, request for proposal for the new testing contract that we'll be implementing in the early part of next year. So we'll also include a new law test that every applicant will have to take. Remember, if you recall, instructors take it now. All students, everybody will take it sometime in early part of 2012. We'll give you plenty of notice when that's going to go into effect. But it's really taking straightforward questions out of the law book, just as they are. The second document presents forward the regulations we're talking about changing, and we will get them in the final form for the public hearing. But these are the changes we're talking about. And they're very basic things that we provide in all the other licenses. If you have anything after you read the document in the next week or two, at the most, please give me any suggestions that you might want, other things you think should be changed. As you notice, we give you the NAC number, what to look for, where we're going to make the change. Okay? So that, is there anybody who sees anything right now you want to bring it up? Go ahead.
I just wanted to go in right on expertise. I have a couple of questions about I wasn't aware that the test was going to be starting, Ms. Gloria, next week.
We'll be accepting.
Except that.
Well, I mean, that's the same thing.
Yeah,
except that
we'll be
we
scheduling, right.
Test date, and the participant is able to take the test. So that's the participant that's going. I just want to get a thorough understanding of the walkthrough. So if a participant comes into the state board with an signed affidavit saying that my grandmother did braiding and taught me braiding for a whole year, then that student makes an application, pay the fee for the written and the practical. So if a student wanted to take the exam, go to school, go to whatever school for the 250 hours. And it has here, when I was looking here, maybe I'm reading this wrong, but it had a school approved by board or...
In other words, a school like yours is approved by the board.
So it has to be a cosmetology school for the 250-hour
Yes,
program.
or if they want to create a school that's not established yet, they'd have to come before the board. Now, the board has not allowed any new specialty schools as long as I've been here. They've required, basically, a school has to be a full-service school.
Right.
So right now,
In other
that
words, it just
play,
could- sorry, Mr. General, it couldn't just be a braiding school.
Right,
Right
it has to be a
now,
county school of
yeah,
cosmetology.
approved school like you guys have.
Okay. And the practical. Because reading here, it said that the person that was braiding hair couldn't use glue, couldn't use those kind of things. Well, my biggest concern is, and I have to say this to the board, and I was an advocate for the braid license in the very beginning, until all these surprises came, I guess, to all the school owners and a lot of the cosmetologists that I'm just been getting some feedback from. Normally, in all the other states, if the test is an NIC test, I have a copy of that test. And one of my concerns is that test covers braids, weaves, extensions, chemistry, all this, lots of stuff. How these individuals are going to pass the test?
It's not just, this will be on braiding, am I correct? Because
Right.
it's been presented to them because they can pull the questions, those type of questions out, and that's all that's been done.
Right.
Am I correct?
Right,
That's
that-
all that's been done. They can't go into the other, they
won't be tested
all
on.
that we'll be testing on is the sanitation, the infection control,
Right.
and if they can actually do the
Different
perform-
types.
Oh, so they're not going to be getting, because the braider's license with NIC is going to give them the license to go other states to practice what all the other states are practicing.
That's not what we've asked.
Oh, you just asked for just a separate
Right.
braiders only?
Braiders
Every
only.
contract with NIC, they can scramble the test.
Okay.
They also pull questions that are not pursuant to our...
To any of those other
Right.
subjects.
And our law specifically is it's almost identical to Ohio's law. It's in fact, the definition we used was Ohio's.
Okay.
It's
But
specific.
because that was I'm concerned about, because I had given the Ohio law to our state board here, because the school I'm working with has a braider's license. So I know that braider's license. I know that braider's license well. Those braiders, they braid, they weave, they lock, they twist. In the state of Ohio, I don't know about what our state's going to do. That's why I'm asking.
Yeah, they can use glue.
Right, they
Things like
can't
that.
use glue, but they can do the other services. Because one of my biggest concerns, and I will be recommending people that I feel that, because I want to see them out the kitchen braiding hair,
Yeah,
but what's going to take them out to braid 8 hours for somebody and give you half the money anyway? That's my look at it. It just don't make sense.
They're not allowed to cut, they're not allowed to do anything.
Well, who's going to monitor that? Because
We are.
let me explain something. I'm going to be totally honest today. And I've called the board, and I have the individuals to call. As a school of cosmetology in the African American community, I have been getting phone calls that there are people now in salons braiding hair. I recommended them to call the state board to let the board know that they're actually providing services.
Are they cosmetologists?
No, they're unlicensed.
They're unlicensed.
Unlicensed braiders.
We're
So-
sure that's happening just like in every other profession.
But the thing is, too,
And we've
Vince,
checked out every
can
complaint.
you hear me out, please? I just want to say this. If you come in, not just braids, but there was an appointment made that was told to me that the lady was from California. She didn't need just braids. She needed color around her edges. Okay? So if you're in a salon with a cosmetologist and you're a braider, you're going to be doing color, you're going to do relaxer, you're going to do whatever that client needs for that $100, $200 ticket. So I just want to make sure that we have our inspectors are going to be assuring us as school owners and cosmetologists in this profession that we keep this profession to a standard that we have always had it. That there be proper investigations going on when there are several complaints. Because if I'm getting the complaints, the state board has to be getting the complaints.
If there is a complaint, it's usually called upon. Any complaint that comes through that front desk or through the phone is checked upon.
Okay.
But as far as our inspectors or anything that go out in the field, they're going to be looking at anything. Just like if a nail tech was out there doing hair, they're going to be cited and fined and possibly come before.
So they have to actually be caught doing the color or relaxing.
Well, that's
right.
That's the only way that we can.
That's the only way it's going to be monitored. And I think that was a big concern with just the industry, period, that with the braid license, because if you've been braiding and you've been doing hair at home, because most of the braiders do hair at home, and we want them to be an asset, not a liability to the community. So I understand the braid license. I don't have a problem with it. I just want to make sure that it's going to be monitored, it's going to be taken serious, where if there are complaints that they're doing color, that they are doing relaxer, that they are doing permanent, that there's going to be consequences, just like if it was a manicurist doing
or a hair designer.
Right.
Or a hair designer, that's a separate license too. That's a breakout license is what I would call it. Is a hair designer. They're not to do nails where a cosmetologist can. So, I mean, it falls under the same category with braiding. I mean, we have to depend on the people out there to let us know if something is not going right, if we're not catching it.
Okay.
Because our inspectors can't be in every salon every day.
No, but I think, but from what I'm hearing, I'm just kind of speaking abroad because I'm in my school pretty much every day, but I have gotten phone calls, about help from cosmetologists that that know people by name that's getting their hair braided and by braiders right now that's not licensed.
You need to call the report.
They say they have. Can I ask them, have you had complaints?
I've received calls.
Good.
So I'm just saying, because I know this is what happens because, as a cosmetologist of 28 years, I know people will do what they want.
Excuse me, Madam Chair. Is there a law against us checking into the appointment books? I mean, is it possible for our inspectors to look at appointment books? Let's say if...
You can't build a case on an appointment book. You have to catch them in the act.
I don't think that would be legal.
I don't see why it would
Probably
be
would need
legal.
a search warrant to do that. You have to have formal complaint. Maybe Annie would know.
Okay, the other side of the coin is if we don't see the practice happening, then it's up to that other person that actually received the service or saw the service to step up and do a formal complaint. That's the other side of the coin. And that can happen.
One of the things we've seen is there's a lot of unlicensed activity in this industry. It's usually nail techs or cosmetologists who don't want to get a license or have not qualified for a license and are working through the back door. And when the inspector comes in the front door, they go out the back door. That's quite common in the industry. It's not like it's a clean industry to start with. There's a lot of problems with it. The issue is this is the early stages of implementing a program. We've advised everybody who's interested that they cannot practice until they get licensed. And so they need to do that. Now, if I had a cosmetology shop and I wanted to be a hair braider, but I didn't have the license yet, I wouldn't operate. But if I did get the license and I wanted color on the edges, I'd ask a cosmetologist in the shop, do the color, and then when you're done with it, I'll take over.
Before Gail forgets, I want her to answer this question.
Say we have a student that comes in and she decides to withdraw from school because of the new braiding license law. Are there any hours transferable from that cosmetology license into the braiding?
I would only think if they apply to the categories that are in the license.
How many schools have braiding on their curriculum?
Miss Annie?
This would be something that you'd formulate in your regulation that we're in the process of doing.
The bottom line is hours transferred have to be directly involved in the categories in which the training is required. If they're not involved in it, there's some other training.
But that would be in our curriculum as a school when we have them do their daily
We
sheets,
would
is that
have to then
correct?
examine each of your your hours and how they apply.
Chapter for braiding and everything.
I have something to say.
Name?
My name is Ruby Jean Davis. I work in the industry, also a licensed instructor. Under your curriculum, there is a chapter for hair extension, braiding, wigs. So, if you are teaching your curriculum, they get a percentage.
But that's of the theory, not all of them have them on their practical.
The practical, during your time when you are teaching that particular area, you should teach them braiding. Another thing I have, the 250 hours, a hair designer is required, but 1,200 as a braider, at least half of those hours should be required for a braider.
Right.
Simply because of the fact you got to know the hair structure, you got to have infectious control, you got to have all of this before you can stand and braid someone's hair.
The legislature was told that.
Ruby, I wanted to tell you, they wanted to give us 8 hours only.
Oh,
And
no,
Mr.
no.
Jim No went before them and got the 250. Now, if this does not work, if they need more, we'll have to go through the whole process again. But at least we got 250. And I mean, I agree 100% with you, okay? They need more. But
It's of the standards of cosmetology.
it is.
Because we have enough household technicians with the licensees that's coming out of school that cannot find work because of the industry is flowing with braiders, hair extension. And then when the licensee gives the person, the hair is off of the head, and all of this is not right.
California has eliminated hair braiding as a licensed activity. It's exempt from law. And the reason it got there was because the hair braiders sued the state. The state lost the case because they were requiring full cosmetologist license in order to practice hair braiding. The state was forced to recraft the law, and they got tired of fooling with it, and they just exempted it. So some states have no laws. There's about 12 states that have some laws, and they range from 600 on the upper end to 100 hours on the lower end. And our first offer from the people who were pushing it was 8 hours training, and you get a license. And we objected to that violently. We said 600 was more reasonable, and the compromise was 250.
But due to the fact California hours is different from Nevada hours, other states' hours are different from Nevada hours and laws, this board and the school should stand up for 600 hours because it's too many people are going to buy hair, putting on people's head, and then the ones that have license start.
That's right. You're absolutely right.
Hello?
You are right.
And that's my opinion about it.
Thank you.
Anyway, is there anybody
I just
have
wanted
issues?
one other question before I sit down. Within this next year, because in that way we can kind of make some decisions for the 2013 legislation, is there any way that the schools, we could get the information of how many people walked in off the streets with affidavits saying that they were braiding hair for over a year and didn't get licensed? How many that didn't get licensed? And then that way we can advocate differently for 2013.
Yes, we can produce that.
Okay.
Yeah, right now
That's an
we're at
excellent
0.
suggestion.
Yes.
I just wanted to say one thing that you were speaking to, and I'm a public member, but one of the things that I've seen by sitting here in this position is that 90% of you people out there, the schools and the hairdressers, you all do a fabulous job. And I think the important thing is policing your own industry so that these people don't do these things. Because you girls really do work hard and for your money and to be out there. And I just want to say to you guys, I think you all do a good job, and maybe you can report these people to us as you catch them.
Yes. Thank you.
No, I agreed with Ms. Ruby that I thought that the amount of hours was a little bit unjust.
business.
Yeah, we did too. My staff, Gloria and Annie, and we have two others that are hair braid qualified. They're full cosmetologists. They've experienced it. They were all in the $500 to $600 bracket. But the legislature didn't want to hear me at that level. They were willing to talk. Like I said, it was a fight to get 250. But that was to keep us in the game. Otherwise, there was a strong push to just take hair braiding completely out of the licensing system.
What was your name, Ron?
Liz Suarez.
So we're coming from the same position. Is there anything you see in here? If you don't see it today, please get it to me in the next week, because then we can begin to put this stuff together in some kind of format that the board can start talking about for public hearing.
Jorge, what's the cost for them attending school 250 hours? What is the cost?
The cost?
Yes.
I can tell you what the schools charge now. They charge, an average of $10 an hour.
Yeah.
So you can figure it's about $2,500 plus or minus with a fee on the top.
I would pay that easily because, what Gwen's expounded on, this is going to be so out of hand in about 6 months to a year. Till all these people that have paid $19,000, $18,000 for school, I would be truly, truly upset because, as you said, they're doing it at home, not licensed. They're doing everything. They're going to go into the shops and continue to do everything that I come in and say I want. I want color. I need a relaxer. They're not going to pass that to a cosmetology to take part of their money or half of it. They're going to do it. And if you can sit here and think otherwise,
Let me explain something. A lot of these, now like the braiders, for instance, let's take the threaders. They hired a high-paid lobbyist that went in there and took it out completely from under our jurisdiction. As far as we can check on them and do whatever, but we can't, our hands are tied on that. When the braiders came in, we had to figure out a way that we could at least control some of that so we know what they're doing out there. If those hours are not working, we can add hours. We did this in the past, I believe, right after I first came on the board. We upped the hours of each of the different entities. But the thing is everybody has to make an input here, and not just a few. If Mr. Jimno hadn't been up there, they'd have went through with 8 hours. 8 hours, you can't even get sanitation and infection control on that, much less knowing what the structure is, your circulatory system, any of the stuff that's really important. I realize that our legislators do not understand a lot of that because they've never been in our positions. And so it's up to all of us to step up to the plate and let them know this does not work.
Is there going to be a mandatory amount of theory for braiders as there is for the rest? We have a maximum, like for cosmetology, it's 250 hours. Have we just developed the maximum theory time for the braiders? Because it's only 250 hours.
Yes, it's broken down into 75 hours of infection control and that sort of thing. If you read the law, it specifically states the breakdown of the thing. 50 hours of it, the 250 is practice on the clinical floor on a person. And there's law, infection control, and makeup of the hair, skin, and surrounding tissues. So they at least understand what they could be doing by accident to a customer. And we have concerns, things like the youth of the people, they start braiding too early and they start pulling follicles out of the hair, and they can't be recovered. There's no way to replace that, all the way to tension, diseases that are transferred accidentally, what kind of diseases you might see on someone's hair, things like that. Those are the basic stuff. That's all I could get away with was the basic stuff and 50 hours of practice.
My name is Victor from Expertise. My question is, as an instructor, if my school offers that program, do I have to be the specialism braiding, or do I have to get a special license as an instructor to teach that new career?
I wouldn't think so, because that's part of the ladies and pivot points and those, it's already part of theirs.
Let's put it this way. If you're a cosmetologist, that's a cosmetology instructor, you qualify automatically.
Okay.
If you're a hair designer instructor, you should qualify. That's what we'd have to look at. If you're a nail tech, it's not going to qualify at all.
My name is Benita Williams. I'm with Victoria. On number 4, it lists that the licensed braider may only trim the hair extension. I have to say, I think as soon as you put a pair of shears in someone's hand, it goes from a trim to a haircut. So I don't know that they necessarily know where to stop. So
Basically says when you put an extension on, you can only trim it to make it even. You can't give them a haircut. So that's going to be one of those that are tough to deal with. You guys know what cosmetologists do. They know it's illegal, but they'll do it anyway. We know that. I mean, that's what happens every day now in every other profession. I mean, every other service that we have. So we try to catch them at it. And the message is, the more we cite, the less we see of it.
Will the salon manager be accountable for that, or just the licensing?
They could deal with it the same way as any other service in there.
Which
If
manager
they're violating
has
the
accountable
law,
also?
permitting illegal activity.
Okay, my name is Dorothy Muhammad. And my question is, clarity, did you say that there was an age requirement for braiding the youth?
No, I said we're concerned about the little girls having their hair braided way too young and they end up with scalp damage because of the braiding that's done. And many parents don't understand the vulnerability of a young child's hair, and they start pulling it too tight. And it looks good, but some of the girls don't recover from it because it pulls the follicles out.
So how are you going to monitor that? Are you going to set an age requirement?
We're not going to be able to monitor that. We're going to try to teach them that that's what they have to worry about because they don't know now. Most of them don't know that.
Will that be taught in the school, in the curriculum?
Well, that's
how are you
the
going
schools.
to
If
teach
the
that?
schools are going to teach a class, they should have those kinds of issues included in the theory and the practice.
So it will be mandatory by the board to
For the
provide
schools
that
to
type?
teach it, yes. But the individual operator is going to have some discretionary decision making. But if they take on a 3-year-old child to braid their hair and something permanently happens, they're probably going to be found as malpractice by the board when it comes before the board.
My name is Cheryl McElroy with Expertise. I agree with Benita. My concern is you're giving them permission to trim hair, but you can't trim without cutting. You with me? So therefore, in that curriculum, there should be some kind of training of cutting because you're putting shears in someone's hands, you don't know how to hold them properly. They're going to go to another level.
That's the responsibility of the school to understand the regulation and teach the process properly, to articulate that to the students. That's in the curriculum. That's what the school should be teaching.
And I understand that's what the school should be teaching, but I believe the biggest portion of your applicants are going to be the applicants that has never been to school.
That's correct. And that's why the test for practical is going to be tough. This is not going to be a giveaway.
Okay.
We're training on the 2nd of October. We're training the raters and their instructors not to give it away. I mean, if they do not understand the different portions, and just because their grandma taught it doesn't mean that they're competent. So we're going to be very, that was the only tool that we had left to play with. So that's going to be a tough test.
I think we can just do nothing but monitor it at this point.
And then if need be, we raise it to 600, 500, 600, whatever we think that is needed, because this is a test, it's basically going to be a testing period to see what they actually need to be taught, because it's not working.
The other options are too is, every time the board has a meeting, there's an area on that meeting agenda for public comment. And so if you're experiencing some of these negative side effects in the community where you found somebody had a pair of scissors and instead of trimming the braid, they trimmed the hair. Those you need to bring up in those public comments. That's where you can make the difference and to kind of self-regulate the industry just from your own observations or the observations of your customers who report problems.
Okay. Hector?
Yeah, Victor.
Victor,
Yeah.
I know Victor.
Yeah, Victor. So my understanding is State Board is going to establish or has already established a curriculum for grading. In 250 hours, they have already established what that the school are going to teach on what areas, infection control, disinfection, how many hours for each one. Do we have already?
What happens is the schools propose a curriculum.
Okay.
We review it and say, does that fit the standard that the law requires? If it does, we leave it to the school of how they construct that number of hours of what they teach, because they've already met the standard of our standard. In this case, 75 hours has to be a particular set of topics. And we leave that up to the schools to determine what hours need to be taught in it that meets that goal, that allows the student to pass the test or any written test or practical test.
Yeah, like an
Just
example.
like you do now for any other course.
Yeah, like an example. What is going to be the minimum hours for disinfection control?
Yeah, well, there, in the law it says it. It specifically states how many hours for infection control and skin care and diseases. So it's infection control and diseases to be aware of. It specifically states it in the law. That the curriculum developers need to read the law and then say, how would we seek to teach our students so they can be competent when testing? It shouldn't be that difficult because most of those hours are in your regular curriculum anyway.
I have one more question. I believe I heard you say you were starting to accept applications October 1.
Yes.
So when is the training going to start?
What training?
For grading, the curriculum that you're going
Well,
to
the
be.
schools can start whenever they want. They have to say to themselves, do we want to train them? They already have some experience in that, and they teach some of it, but they don't focus on it. In our case, we're only the testing and regulatory agency. We don't craft your education for them. We just say, if you go to school for it, you have to take a 250-hour course with these topics, general topics in there that you have to train your student. The one with the affidavit says, Grandma taught me over the last 5 years, and I've done it at home, and all my sisters and brothers, the brother's wife and that kind of thing. However, they're coming in and say, I know how to do it, so I want to challenge the test, is what they're really doing. And they come in and take the test, and if they can do it and meet the standards, they'll be licensed. If they can't meet the standards, we're going to recommend that they go to school.
Oh, so you can just come in and apply to take the test without any training?
Under certain conditions, you have to swear
Doesn't
to
mean
an
you're gonna
affidavit,
pass.
which I thought,
Well, there's no need to even have a curriculum then. I mean, just open the door and let them come in and apply and take the test.
Well, that's not quite accurate, but
Okay.
the most important thing that you want to do is that if you see someone braiding hair, is to ask to see their license. And if they cannot produce a license, call your chief inspector. That is the best thing that you can do to ensure the livelihoods of all your students and all of the subsequent licensees. There is no other option other than self-regulation of that part of the industry, because it is a new license. It will require all of us to participate to make sure that the standards of ethics are maintained.
Now, also I wanted to add to what he's saying as far as the affidavit goes, that says that they have been practicing grading or they've been taught grading. Do you honestly think that anybody that has not been to school knows sanitation control and infection control?
Absolutely
That's on the
not.
test. That means they won't pass it. they will be almost, if they want to do this for a living, will be forced to go to school.
But under the cosmetology law, it is required they go to school before they petition the board for an examination. So it's a disparity right there that I can see.
Slight disparity.
Well,
The slight disparity is that someone has a cultural background in that type of hair braiding technique. That is the modest disparity.
Do you guys understand that this is a nationwide movement to nickel and dime pieces out of the cosmetology industry and unlicense them? In Florida, they tried to unlicense all of it.
In Illinois, they tried to do the same thing.
So this is a movement,
Yeah.
and your own people are doing it to you.
Yeah.
People who don't want to comply with the regulations.
I can also say that the NIC, the National Interstate Council of Boards of Cosmetology, started over 3 years ago putting the test together for braiding because they saw this coming. So they're kind of ahead of the game in that aspect because back east, now it's coming all of our way.
Washington, D.C. has 100 hours of training. That's it.
Yes. I want to say for the record, if I may, braiding is a cultural thing in its beginning, but everyone braids. I mean, you got just as many. I mean, you got Caucasian people on the rise who are braiding. So I don't want to hear you say that is your own people doing it to you.
It is.
Cause
Let me put it this way.
It's there. If you want to learn
Worldwide,
it.
braiding is done by every company.
Yes, sir.
But in
Well,
the
that's
United
what I want
States,
to
the
hear.
push is done at this time is being pushed by the African American population, and some is resisting it. So we're getting mixed messages from the field from everywhere. The issue is in D.C., which is heavily populated by African Americans, it's 100 hours. In Missouri, it's 600 hours. There's no rhyme or reason to any of it. It's just that people don't want to be licensed anymore.
Right. But the only thing is the board is there to protect the public. That's all my concern is in our state.
That's our
Right, exactly. So that's what we as licensees, we're just trying to guarantee that we are protected as well. And I think that's what I'm hearing from everyone.
Is petitioning the board open to all cultures, or is it just minimized?
No, it just says hair braiding, period. All cultures, all, from any country, anywhere.
But
Okay.
it was African Americans that did petition the board originally, if that's the question.
Well, I didn't hear you, I'm sorry.
It was African Americans that petitioned the board originally.
Originally, but it's open to every
It was,
nationality,
but
every...
That's where the statement was made.
We don't
because that's
use-
in the course.
We don't even use the word natural. We just say hair braiding, period.
Yeah.
Because it means any culture, any from anywhere would qualify for it if they have to meet the standard.
But would that be, say, in your Vietnamese community where they can come in and petition the board because in their culture, they have been doing nails in their country forever and ever and ever, and because they've done it, that's why they were raised, they come in and petition the board without going to school?
You're adding something
No,
to
I'm
this.
not. I'm just asking.
The law is not that way at this time. The law is they need a license and they need 600 hours.
But even though they've been doing it, they can't petition the
It was
board
already
to,
established.
with going to school.
The board didn't have anything to do with this. We opposed it,
Right,
and we wanted more hours.
that's right.
It was,
We wanted education behind it.
Any culture can do it. Threading, that's how threading came in. The Indian population from India
It's your
who
legislative.
migrated did it by going to the legislature themselves and sabotaging one of our bills.
Yeah.
That's how this occurred, the same thing. Any culture can do it.
Yeah.
We did not want to give up the fact where we were before. That was not our choice.
And this
We
was,
went down
it was
particular-
fought very hard.
Yes.
Because I was up there and I helped to do that, and I know.
Who proposed the bill for no braiding license? I mean, how did it start?
The thread or the
The
braiding.
braiding. How did it start to get to? How did it get to the legislature? We don't want to
It
license.
became a legislative, an amendment to a bill we were pushing through that we'll talk later, but it was done by African American, with African American support from other states that talked about wanting to de-license hair braiding, period. The senator that agreed to it was concerned about training, and he offered up 8 hours. I fought that tooth and nail, but it was the African American population and other agencies that had come and threatened us that if we weren't moving in this direction, they would take a look at causing problems for us. Now, we're not either advocating or not advocating. We're going through the legal process where people have rights to do claim whatever they want. If they can get a legislature to sponsor it, and it's off and running, and the legislature doubled it. We ended up with our own bill being sabotaged. But the problem is we think we came up with something that's livable, something in the middle.
I just think the best thing is we just need to watch it.
Yeah.
The school, I'm sure all the school owners are going to want from 2012 to 2013 legislation is back in session come January. We can lobby, make some changes, come before the board, maybe talk to the board members so we can all be aware. And you'll have your stats. Because I just, from the way the other school owners and cosmetologists in their salons that I spoke with, they're really upset. It hit everybody hard. Nobody really saw it coming. So now we just have to monitor it and we see what happens. We see how many how many licensed graders that did not attend a school of cosmetology get licensed successfully, how many complaints maybe the state board inspectors have, and we can just look at it and then we can go back and say, you know what, there's going to be no more grandfathering in. Everybody goes to school. This is what they need to be taught. Even get pictures from people that have damaged scalp, hair, statements. We just know we have to do we just have to look for it now.
I wanted you to be aware that when these things get started in the legislature, your board has, which represents you, a lobbyist. If we did not have a lobbyist, there are times when things come up, as Mr. Jimmer will tell you, we don't know anything about it. And all of a sudden she'll call and she'll say they've added this on to this bill. And we don't know anything about it. That's how we find out stuff. So we do have a lobbyist, which is, she's helping all of us.
Right.
So I want you to know we don't just let them push something on us, but we have to respond to it because it's a state law.
Okay. I just wanted one last comment on this, if that's okay, Mr. Jimno. One of the things that's always important to me as a member of the board is when I look at the number of hours that are required for a license. And so in this particular licensing category, it requires 250 hours of licensing. That's the minimum. That's your item number 7. And then it gives you an OR. And in that OR, it says certification proof of licensure from another state. It's very important to me that the policies of the board still require that minimum number of hours. So even if they are coming from another state with a license for hair braiding, for me personally, and I'm not speaking on behalf of the board, I still want to see the minimum number of hours requirement. So if that other state issued them a license for only 8 hours of training, I still want to see another 242 hours completed in our state, regardless of whether they have a license from another state. And I speak to this particular qualification in our other licensing categories because for me personally, and I do not speak for the other board members unless they speak up, it's very important to me that when we start talking about reciprocity or giving people licenses from other states, that our minimum number of hours are still held to a value. So in aesthetics, if you come from a state with only 600 hours and you're still licensed, I still would like to see you required to have another 300 hours. When you come from manicuring, it's 600 hours as the minimum licensure. If you're coming from Alaska, where you only are required to have 12 hours, I still want you to have 400 or 580 some odd more hours before you can use your license to get a license in Nevada. So that, for me, is one of the biggest concerns. So as we go through this process, I would like to see people a little bit more proactive about how licenses are given to folks who are saying that they have the same skill set as our Nevada-trained students who are then becoming licensed. So that is the kind of another little segue. And I certainly don't want to get off topic.
Okay. To let you know the legalities of that, though, reciprocity is a unique issue. There's lots of case law on it that says you got to be really careful. If somebody has 1,600 hours, like in California, and they come here with 1,800 hour requirement, you can't force them under our current laws to take the other 200 hours.
Right.
Good thing to think about. We'd love to do that, but we have to be very cautious. So the law doesn't allow us to arbitrarily pick and choose. But from 12 hours to say 600 hours, then we can refuse to accept the reciprocity. That's as best as we can get to. So we're actually consulting the AG's office, Attorney General's office, to talk about what authority I have to reject some of those issues. So with that, move on. Now, if you have any suggestions, regulations on the first topic, please send it to me, or the second topic. The third topic of the day, hopefully we move this one a little faster, is a cleanup from 2009 that had some minor corrections to the law. And you'll see, in this case, you'll see they're all, the first NAC is restrooms, and we talk about walls, floors, ceilings. These are cleanup language from 2009 that we respond back and give them cleanup language. They're all really basic things, and it was triggered by the threading. When we went through 2009, threading was pulled out of our chapter and then stuck back in as a certificate. Threading used to be part of the cosmetology industry and the cosmetologist license. Now it requires they can literally operate without a license. They just got to come to the office. They write down their name, where they're working, where they live, etc. They get a certificate, and they can open a kiosk or a standalone business. We have no control over it. So regulations in this, basically the fact that we have the authority to inspect them, we have no authority to do anything for them. So this adds the authority, like if you don't use a string more than once, that's a violation. If you don't wash your hands, that's a violation. These are basic regulations that all of you understand and probably are aware of. But it adds in the threading part. We had to go back to the legislature to get the authority to do that because they forgot 5 words in the chapter 1 and chapter 2. So we didn't have any authority to do it. So if you have, after you review this, if you have any comments or suggestions, please send it to me directly and we'll take a quick look at it. This one has been, it also has some fines for activities that there was no fines included for it. And this one has been sent to the Legislative Council Bureau. Their attorneys have looked at it. We think these laws are in good shape for passage. We needed a public workshop. After that, we'll do the public hearing. We'll have to go over to the Health Department for approval, and then we go to the Legislative Council, or Legislative Commission to get passage. If you have any, please send them to me. Any questions on what you're seeing? This one also included, I believe, the apprentices. We were seeing violations in the apprenticeships where in the rural country, they were actually charging the students for apprenticeships. That's not allowed under the law. And we caught them ourselves. We were doing some inquiries. We got a complaint or an inquiry. And how we caught it was really interesting. Another state agency was picking the tab up for it. And they made an inquiry of us and said, wait a minute, that's not supposed to happen. What's going on? So we ended up putting a regulation that clearly defines that we're not supposed to do that and what happens to it if you do. Okay? The last item of the day is the regulations involving, I just described the last item already. The last item is about the apprentices and some additional fines that were added. Because the apprentice supervisor, who was doing all the monkey business, never had fines for anything. They could get away with it and then just slap their hand and that's it. So we had a fine for that and made it very clear that if you take an apprentice, you have to be 60 miles from any city in the state that has a school, from a school basically. And you can't charge them anything for the training because you get free labor at minimum, and they have to be an employee of that salon and paid as an employee with minimum wage. And then you get the benefit from all their work because they're teaching them to do shampoos and they do styles and all that stuff. And you get to collect the $40, $50 or whatever, and they get their $8. So that's what that's about. If you have any other solution, any suggestions or additions, please let me know. The other three that we've talked about, the other two that were these are two simple ones. The ones that are important to you guys is hair braiding, we know is a problem. We think we've covered the bases. Bottom line, without self-policing, we're not going to solve that problem. Right now, we have no way to stop it, period. The kitchen industry is wide open. And how many people are doing it, we have no idea. We want them to go to your school, and we want them to be licensed and to comply with the regulations. And so that's why you need self-policing. Any questions, any suggestions? I'm here most of the time. Feel free to make sure that I know as soon as possible, because we'll be crafting the final regulations so we can get ready to send it to the Legislative Council Bureau for the attorneys to start looking at it. They need to know that it fits in the law, it's legal, it fits all parameters of the current regulations we have, and we'll easy to work with. Any other comments? I really appreciate you all coming, by the way.
Mr. Leader has a
You know, I brought this up to our northern meeting, and I was just going to make sure I bring it up into the southern meeting also, that using the term advanced or medical in connection with any description of a person's practice in any branch of cosmetology, or otherwise holding out to the public that you're advanced or medical practitioner, it's now going to be a fine. So if you see somebody who's calling themselves a medical esthetician, that's another opportunity for you to call our chief inspector, because that's not an acceptable term in the state of Nevada.
There's no such license.
No such license, that's right.
You see a lot of these people who are advertising the paper for advanced medical estheticians or aesthetic. They can't do that. So when we see that, or if it's reported, we send inspectors out. Yeah, it's very busy. And I'd like you to know that Annie Curtis, the chief inspector, is doing a yeoman's job of helping ram out some of these things into place so we don't have to talk about. Her staff includes Jeff Green over here, one of the inspectors you guys see, and our newest inspector, Diana Ball. She deserted the DMV office to come to work for us. And of course, Gloria Alexander, who's done an outstanding job of helping make sure I understand what braiding's all about and all these other things. Because I don't know. I have to live and die with the experts.
Mr. Chino, one thing we did not do is roll call. Do we need to do that?
And I have to thank Mr. Leader for
Now,
his
we have,
work.
no, not a problem. This, by the way, is not a formal meeting like a board meeting. It's an input meeting, so the board either can come or not come based on their time frame. I'm really proud of all the boards. They all came.
We do have an report.
Yes, we do. Our newest board member is Christopher Neil Hoffman, and he is out of the new northern Nevada area. He's been a cosmetologist for a number of years. Do you want to say anything, Neil?
No.